Hello, 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 and welcome everyone. Please be sure you hit that like button on your way in. Do we have some drama coming out of the Bryan Kohberger case? Sparring match going on between the prosecution and the defense. Okay, let me just get this set up here and we will get going. I will pull up the just let me make sure that everything is coming up on here. Let's see if we're all set. Okay, we should be all set here. Good morning, Nana. So good to see you. Well, good afternoon here. Good morning, probably where you are. So there's some new documents that have been dropped, and there's one that I want to go over because that's where all the drama is, and we get a little bit more information on what's going on with this case too, and maybe what does the prosecution have, etc. Okay, I'm going to close studio because I don't want to, I've got to update my graphics card apparently. Okay, so let's get going here. Let's share this. All right, so we know from the last videos that we have done and gone over some of the court documents that the defense is saying that the prosecution, they did have a deadline of December 18th to get in their expert witnesses, their list of expert witnesses and their curriculum vitae and their opinion and whatever. Now there's going to be a battle here that the judge is going to have to jump in and say, enough. Enough is enough. This is the way things are going to go. So, but in this, we also get to see a few more things. We know that a lot of the exhibits that the defense filed, well, all of them really, that the defense filed, were filed under seal. But we get a little bit of indication in this document as to what that information is, okay? So this is the state's objection to the defendant's motion to compel materials and for sanctions. So let's go over it. Like I said, we went over the document already where the defendants filed their motion to compel and asked the judge to impose sanctions on the prosecution. They're saying that the prosecution didn't file opinions and materials and all this stuff with their expert witness filings. So the prosecution is going to clap back here. Okay, so let's go through this. It is 11 pages, but we're going to go through it quickly because there's a lot of things that we can just jump over. So it says, comes now the state of Idaho by and through the Latah County prosecuting attorney and respectfully objects and moves the court to deny the defendant's motion to compel ICR 16B7 material and for sanctions. Now, the defense filed this on December 27th. Now, as far as I'm concerned, and the prosecution is calling this out, there's some information here. We know that the defense is constantly saying, oh, we don't have this information. We don't have this. We don't have that. But the prosecution you're going to see here is calling them out on it, because if they didn't have that information that they're claiming they don't have, how can they file motions about those things? It doesn't make sense. In one hand, you're saying, we don't have this information, Your Honor. But in the other hand, you're filing motions regarding that information that you're saying you don't have. You can't have it both ways, right? So the prosecution is clapping back here. The state has been actively engaged in replying to the defendant's request for discovery, including materials related to potential expert witnesses, since the original discovery request was filed 2 years ago on January 10th, 2023. And we've seen it in a lot of the replies when the defense, and I understand the defense has to keep asking for discovery to keep things relevant in the record. I get it. But I think they're at like 21 times. And they don't specify what discovery they're saying that they're not getting. And in the motions that they do say they haven't gotten this discovery, but then down the line, they're making a motion against that information in the discovery that they said they didn't have, right? So it doesn't make sense. 16J contemplates discovery involves a continuous duty to disclose, which the state has and will continue to comply with. And that's what I just said. This is continuous. As they get new information, they have to give it to them in discovery. So if they don't have anything new, they can't give anything new. But the defense has basically just continued to put in motions for discovery. And like I said, I think they're up to number 21 request or whatever. Like as if the prosecution doesn't know that they have to hand over discovery as it comes in. It is. It's going to become a circus. Hey, Kate Bell. Hello, hello. Okay, so they are saying the state has and will continue to comply with ICAR 16J, okay? The specific continuing duty to disclose evidence that ICR 16 compliance is not a one-time event. So in other words, what they're saying is you don't have to continuously file these motions to request discovery. We know we have to give it, and we know that is a continuous requirement. You don't have to file requests 3 times a month. We know we have to turn over discovery as we get it. So that's kind of calling them out on these 20 odd times that they've requested discovery. Defendant currently notes this case involves a substantial amount of discovery. And call them out again. Defendant cites over 68 terabytes. Can you imagine, you guys? And the state does not dispute this. Good morning, Carol. The discovery received by the state from multiple agencies has been provided to the defense in the same manner that it was received by the state, as it was provided to the state. So they're saying the way that we've got the information, we don't even try and redact it, and we don't do nothing with it. We hand it to you exactly the way we've got it from whatever agency, whether it be the lab, whether it be FBI, whether it be CAS reports, police reports, whatever it is that they get, they're just boom, here, forwarding it that to you guys too, to keep us on the right side of giving discovery as we get it. Then the defense turns around and says, well, nothing's in order. Well, you can't continuously say the prosecution's not giving you stuff when they are, and they're giving it to you the same way they're getting it. So you know what? If it's not in order, they've got to go through it the same way that you've got to go through it. Like, to me, this is just like filler, as we like to call it in the legal field. Filler. When you've got nothing else substantial to say, you got to use fillers. And I just find it ironic, you guys, as we're going over this, that I get it. The defense has to throw whatever they can to try and get the best possible outcome for their client. I get it. I worked for criminal lawyers for 30 years. I know, I get it. But when you start, like I've previously said, start going into 1800s law and, trying to rewrite how things are carried out in the judicial system because you don't like how they are, like the grand jury proceedings, for an example. And you spend, I don't know how long in typing up a 400-page motion. It's ridiculous. And it's like, I seen this a lot when I was, working in the legal field. I'm retired now. I seen this a lot, and I know Canada law sometimes is a little different than American law, but this is the same everywhere. I don't know. I don't care what country you're in. If you know you've got a weak case for your client, you are going to pull every trick in the book. And I call that burying the prosecution in paperwork. Okay? So I feel a lot of this is what the defense is doing. Okay? They're just trying to bury them and then complaining that they're not giving them things in timely matters. Well, they are. They're giving it to you as it comes in. They're just not putting it nice and neat with a little bow and pointing out like they would have to a kindergarten. A is this. B is this. They're giving it to you exactly how they got it. They got to go through the motions of, deciphering what goes where and grouping things together. You guys got to do it too. The prosecution's job is not to tie up everything in a cute little bow for you. Their job is to get you the discovery that they have. So they follow the rules. And that's what they're doing. Now, if you want little pink dresses and little cutesy bows, you shouldn't be dealing with cases of this magnitude. Okay? Stick to, like, I don't know, small claims court or something. I don't know. Anyway, so the state's not disputing that there is a lot to go through in this, but they're also stating with this, we've had to go through it too. If you can't do it, then hire more people. And on that topic, I have never, ever, ever seen a case that has had so much money and resources given to a defense team. Multiple investigators, multiple experts, multiple this, multiple that. I've never seen this. You go back, you guys, and like, fact check me. Look at some of these big cases. We've never seen this kind of money thrown at a defense and say, here you go. You got unlimited. Bryan Kohberger is getting a legal team like Elon Musk would. You know what I mean? Like, as if this is coming out of his pocket. And it's not. It's the taxpayers of Idaho that are paying for this. Okay? So just a fun fact there, like, this legal team is crying foul every turn you can look at. But if you're going to tell the story, tell the whole story, because you've gotten so much more resources than anybody I've ever seen. So let's continue. The discovery received by the state from multiple agencies has been provided to the defense in the same manner it was provided to the state. The state is in the same position as the defendant in this regard. And there's a little number 1 here. So let's quickly scroll down to that and see what it means. Number 1 right here. See that? Okay. Defendant complains and appears to represent that he has not been provided with adequate information from the state. This is patently untrue. By way of example, they're going to give an example. To appreciate the true degree of analysis and use by the defendant of discovery that has been provided, see, they're saying this discovery's been provided, the court need look no further than the extensive detail in the defendant's motion for a Frank's hearing. Boom, there you go. That's what I was just talking about. You can't say that you're not getting this information, but then file all kinds of motions regarding that information. You can't say, I haven't had a chance to go through it, but you're filing motions regarding what is in that. So good that they call that out. The 20 plus supplementary discovery requests and related materials and the many other detailed substantive motions he has filed. So there, the state just called them out. You can't say you're not getting this discovery, but then make motions regarding that discovery you're saying you didn't get. Oh, boy. Okay, the court record will reflect that the state has provided extremely detailed responses to the defendant's request for discovery and the motions to compel above and beyond. Oh, thanks for mentioning me. Oh, isn't that nice of them? I'm just joking, you guys. So above and beyond what is required by Rule 16. And I find they do. Like when they do their supplemental or their responses to requests for discovery, the prosecution has given very detailed information on when they gave it to you, how they gave it to you, and what was in there, and on what date. Usually you don't have to do that, but they have done that for the defense to help the little kindergarten children find where all this stuff is. And again, I say that because it irritates me when you have a defense team blatantly making up stuff to make the prosecution look bad, saying they're not getting discovery, but you're filing motions regarding that discovery you didn't get in detail of what was in that discovery. It's sickening. So on December 18th, the state, in compliance with the court's order, filed its guilt phase experts consistent with ICR 16B subsection 7. These disclosures were filed 7 months and 24 days before the commencement of trial. As of the date of this filing, we are 7 months and 12 days before the commencement of trial. Nevertheless, defendant argues that he has been prejudiced and requests sanctions. Defendant's arguments are without merit. Okay? So they're going to go over, and we have gone over some of this, so I'll just briefly touch on it so you can understand what's going on if you haven't seen those videos yet. The state has complied with the court's order and the Idaho Criminal Rule 16B subsection 7 regarding disclosure of expert witnesses. On December 18th, the state filed state's supplemental response to request for discovery regarding expert testimony in compliance with the court's unredacted sealed order governing further criminal proceedings and notice of trial setting. I showed you guys that, and that was on October 9th, 2024. That order stated as follows under Section C, Discovery and Expert Disclosures. We've already read this. Experts, a list of experts the parties intend to call at trial, including a copy of the expert's report consistent with ICR 16B subsection 7, and a copy of the expert's curriculum vitae shall be disclosed to the opposing party as follows. State's guilt phase experts, December 18th. Okay? That was what was written. Okay? And if you remember, then they had until I think it was December something to file any other opinions and stuff like that. So what they had to file by December 18th was a list of the experts the parties intended to call at trial, including a copy of the expert's report consistent with ICR 16B and a copy of the expert's curriculum vitae. Now, if that expert is only coming in to give their opinion, opine on stuff and stuff like that, maybe they're calling these experts to show, like they're going to have exhibits of like the cast data and stuff like that. They're there to explain, how that all works or whatever. If they don't, normally a lot of these witnesses don't write a report because it's more they're there for explaining how things work or why things came up the way they did. So there wouldn't be a report. But if there is a report, they would have to file it. And this is where they ran into the problems. They only filed 5 of those experts. The prosecution filed opinion letters, right? Their reports, what they found, how they got there, blah, blah, blah. They gave that to the defense. So the other expert witnesses that they have didn't file reports. That's why you don't have it. We're going to get into that in a little bit here. The order refers to, I'm going to just say 16B, okay, which states in relevant part, on written request of the defendant, the prosecutor must provide a written summary or report of any testimony that the state intends to introduce at trial or at a hearing pursuant to Rules 702, 703, or 705 of the Idaho Rules of Evidence. The summary should provided must describe the witness's opinions, the facts and data for those opinions, and the witness's qualifications. Now the defendant has to request that. Okay? So the defendant cites the Moraine case, okay? And what they're saying in here is Moraine was charged with driving under the influence of DURGS. The state filed the following expert disclosure for forensic toxicologists. They said that this doctor that they were going to bring as a witness, that the prosecution was going to bring as a witness, this is what they filed in the court, which is what they are supposed to be filing right now for Bryan Kohberger case, right? Dr. Dawson is an expert in toxicology and pharmacology and will assist the trier of fact in understanding the evidence regarding the effects of this on the behavior and performance of the defendant as reported in this case. Dr. Dawson will utilize known and generally accepted scientific principles of absorption, distribution, I can't say this word, how your body metabolizes things, metabolization, there we go, I got it, and excretion of drugs. I said it, geez. Testimony may include information on the effects of and consumed by the defendant in this case and the possible effects of said, you know what? Whoops. Sorry, you guys. Get it together, Willow. Okay, so then the defense team in the Moraine case said, at trial, Dr. Dawson testified that dilated pupils, confusing speech patterns, impairments to balance, and other psychomotor function, lack of convergence, and green coating of the tongue were all diagnosis indications of marijuana intoxication. Dr. Dawson also testified to the physiological effects of other, you know what, found in Morain's system. Ultimately, Dr. Dawson testified that it was his opinion that Moraine was impaired and unsafe to operate a motor vehicle. The court held that the state's response disclosed nothing more than Dr. Dawson's qualifications, the genetic response, and vaguely described the subject matter, not the content of Dr. Dawson's anticipated testimony. The court held a mere list of topics or general subject matter which an expert witness may testify is not a discovery response that complies with the rule. The Idaho court also stated, even if the state did not know all the details of Dawson's testimony at the time of the initial discovery response, ICR 16 imposes a continuing duty to supplement the response if a party later discovers or decides to use additional evidence. Now, they did do that. They did give a supplemental response, right? But in here, the defense is saying this is what they've done. They didn't do it. And this is what the judge did because they didn't do it. Discovery rules are drafted to safeguard the truth-seeking functions of trials, right? So there's no, surprises, right? The rules are designed to promote fairness and candor, facilitate fair and expedient pretrial fact gathering, and prevent surprise at trial. So by the way of contrast, okay? So now we're going to go to that is what the defense has said. They said, look, the court said that wasn't a proper filing. It wasn't proper. He only gave an opinion that this was going to be an opinion. And he didn't say he was going to go into all these other things, blah, blah, blah. And apparently this doctor didn't, or the prosecution in that case didn't provide any supplement responses, right? So in this case with Kohberger, they did provide a supplemental response on top of what they'd already given. So what the prosecution has said is, by the way of contrast, in State versus Koch, the defendant was charged with lewd conduct with a minor. The state filed the following expert disclosure for an expert. Ms. Yeager's curriculum vitae is attached. She'll testify to the dynamics of delayed disclosure as it relates to child, you know what? The state intends to elicit expert testimony from Mydell Yeager regarding behavior of children who have been this. And Ms. Yeager will testify that it is rare that a child immediately discloses this, especially when they know their perpetrator. Ms. Yeager will testify about the dynamics of child this as it relates to grooming a victim, keeping the abuse secret, the effects and threats on whether the child chooses to disclose. Okay? Koch argued that the above, okay, so the person, the person on trial in this case, okay, the defendant said, his name is Koch, argued that the above disclosure was insufficient because it failed to disclose Yeager's opinions and facts and data behind those opinions as required by ICR 16b-7 Idaho law, right? Koch also claimed the disclosure was insufficient because it did not include a summary or a report written by Ms. Yeager. The Idaho Supreme Court disagreed. The Supreme Court held that the disclosure informed Koch of the main opinion to what Yeager was going to testify, and while it did not specifically disclose that Yeager's opinions were based on her training and experience, which would be better practice, it did provide her curriculum vitae that presumably disclosed her education and experience, okay? And further, the Idaho Supreme Court held that the state does not have to produce a written report where none had previously existed, stating if there is no data, the state doesn't have to produce data. She is simply an opinion witness, noting that Koch could object if the testimony varied from the state's disclosed summary. So what they're saying is, look, we've given you their curriculums. We've given you what we expect them to testify to. Now, we didn't give you all the data, how they got to that point. No, we don't have to. Okay? And if you have a problem with what's being said, that's why there's cross-examination. And that's where, the Superior Court has said that's where you take up your argument with it. Or you object during, the examination of this witness in chief. Object. Or use your cross-examination to examine this witness on what she's said in court, right? The Idaho Supreme Court in Koch discussed the scope of ICR 16b-7 disclosure requirements and looked to the Federal Rule of Criminal Procedure 16a-1g. The Supreme Court noted that the main difference is that the federal rule requires the basis and reasons for those opinions, whereas the Idaho rule requires the facts and data for those opinions, suggesting the federal rule requires broader disclosure. So don't cite what you want, but use Idaho law to try and get it when it's a federal rule, right? Anyway, so they go on to argue this point, okay? But this is where, I would hate to have that last name, Wyckoff. Ooh, what a name. Anyway, so they go on to argue what rule should this fall under, federal or Idaho? Because they both have rules that govern this. And it seems to me, I could be wrong because this is the US and I'm in Canada. It seems to me that the defense is trying to argue their point using a federal rule, but wanting state outcomes. It's weird. It's just weird. Okay, so let's get back to this case. And this is where some information comes out. Let me just take some of my coffee here. Okay. Turning to this case at hand, on December 18th, the state disclosed 25 potential. Okay, there's this little 2. Let's go down there and see what the 2 is first. In abundance of caution, the state included witnesses that the state does not label as technically experts within the meaning of ICR 16b7, but anticipates that the defendant might disagree. So, in this 25, let's go back here. In these 25 witnesses that they said they have 25 expert witnesses, they are saying they're disclose them, even though maybe 22 of those aren't really experts. They're not going to be sworn in as experts, but the defense may claim that they're experts. So we just gave them the whole list, which they didn't have to do. All they had to do was give the witness names and curriculum vitae and all that of the expert witnesses that are going to be sworn as experts, okay? But under abundance of caution, they gave them the list of all the experts they're going to be using for this part of it, right? So the state disclosed 25 potential experts the state intends to call at trial. The defendant takes issues with 22 of the disclosures, claiming they're insufficient. Well, if they're not experts and they're not going to be sworn in as experts, they don't have to file all this curriculum stuff and everything. That is only when they got to file that stuff is only when you are filing for an expert witness. I hope everybody on the same page here. Do you understand what I'm saying here? All 25 of the state's disclosures comply with the court's order in ICR 16b7 and are not the generic discovery response, as presented in Morin. All 25 disclosures encompass more than a mere list of topics or general subject matter which an expert witness may testify. So they're saying it right here. Even though they didn't have to with 22 of the witnesses, they gave disclosures for all 25 that encompass more than a mere list of topics or general subject matter which an expert witness may testify to. Each disclosure informs defendant of the main opinion to which each expert will testify and the CV which that opinion is based on. Give me a minute. Oh, that was bad. I had a cough drop in my mouth to try and cut down on my coughing. And it was just a tiny little piece that was left, but I ended up swallowing it. Oh my gosh. Excuse me. And it felt like it got stuck in my throat. It didn't, but it felt, when you get that, oh my God, something's in my throat. So as I breathed in, it must have went down the wrong hole. I don't know. But as I breathed in, I felt it going down my throat. Mm. Oh, give me 1 second, you guys. Okay. I keep feeling like I need to get it out of my throat. It'll melt. Anyway, so here's where we start getting a little bit of information. Excuse me, you guys. For exhibits S1 and S6, okay? These are all under seal, right? So we're going to get a little bit of info here on what these are that are under seal. The state disclosed expert opinions regarding toxicology results for the descendants as detailed in the provided toxicology reports. So you got to remember, when the prosecution brings in experts, there's got to be a reason behind it. Okay? Now, there's a lot of talk out there saying, oh, they were all doing the, you know what, DRUGS. They were all doing that and blah, blah, blah. So, during their autopsies, toxicology did their thing, and they've got toxicology reports. So, I don't know why really this is I can kind of know why, but I think that the defense is going to try and go with this was some kind of DURGS dealer and not Bryan Kohberger. That's what I think the defense is trying to go at. We don't know, because we haven't seen any of these filings. They're all under seal. But for the prosecution to make a big point about this, and for the defense trying to fight this, and I don't think they want this toxicology report in there, because is it going to show us that none of them had anything other than alcohol in their systems? But on the other hand, so I've got to think that way, because it's almost like it's the defense that doesn't want this in. Now, if the defense was fighting to get this information in, that would tell me they probably found something that, is illegal in their systems. But it's almost like they're fighting to get this out, or to not have it testified about, not to have it brought up, because that would go against their theory that they're going to try and say that this was a DURG deal gone bad and had nothing to do with Bryan Kohberger, right? So that's why I think this is coming up. In addition, the state included the toxicologist curriculum vitae, the CV, which supported his or her opinions. I wonder what those opinions are. The opinions that are going to be talked about, apparently the defense isn't going to like, or they would not be fighting to get this out. This disclosure was not merely a topic list of general subject matter which the expert may testify as precluded by Morin. Instead, it is the main opinion of the CV which supported the opinion as required. As noted by the Koch court, the Idaho rule is not as broad as the federal rule, which requires the basis and reasons for those opinions, whereas Idaho rule requires the facts and data for those opinions. See what I mean by the difference between the federal law and the Idaho law? So that's what I'm saying. The defense is trying to use the federal rules to get more than what Idaho says that they have to give. So you can't use federal rules to try and get state stuff. You know what I mean? States S1 and S6 disclosures satisfy the requirements of Rule 16b7. So here's the next one. Exhibit. Now, don't forget, these are all under seal. So anything we can get, they get talking about these, we can maybe get some little bit of information, right? So S2, the state disclosed special agent SA balance. The state's disclosure was adequately specific. For example, S2 states SA balance would provide his opinion as the general locations in which the target cellular telephones were located at. What? Was there more than one phone on Bryan Kohberger? Let me read that again. For example, S2 states that the special agent will provide his opinion as the general locations in which the target cellular telephones were located at various times before and after the homicides at 1122 King Road, and the cellular phones' directions of travel. Directions, phones. This is multiple, you guys. Do they have did they find a second phone for Bryan Kohberger? And now, this is another one that the defense seems to not want in. Why? Because the defense, and I don't know why more people aren't talking about this, the defense alibi is Bryan Kohberger lives in Pullman, Washington. This happened in Moscow, Idaho. The defense says that he went to this park in Washington to stargaze. Well, this cellular data doesn't show him going to that park at all. What it does show him going to is Moscow. And just before getting there, on his way in the total opposite direction of the park and total different state, it shows him going into Idaho. So for their alibi to be that, no, he left his apartment and he was out driving around and he went to this park in Washington, then why is he in Idaho? Why is his phone in Idaho? He turns it off and then it comes back on again just after the crime down below Moscow, Idaho. And they follow his cell phone data all the way down out of his way and then back up into Pullman, Washington. Never does it show him going to this park. So this is why I think they are trying to do their best to ruin any data that they have regarding his phone, right? But this now has got me thinking that they've got more than one phone of his. Did they find another phone? We don't know because we're not allowed to see anything. It's all under seal. And it's saying multiple here too. Directions, phones. The attached report detailed the target cellular phones analyzed, the dates analyzed, and the direction of travel. In addition, defense was directed to the cell phone records provided by AT&T, which we know is Bryan Kohberger's phone carrier, and test driving files which support the report. The defendant appears to be requiring compliance with the federal standard, which is much broader than the ICR 16b7. The state's disclosure provides the defendant with adequate notice of balances anticipated testimony to satisfy the requirements. Let me just pull this up for a minute here. Okay. Sorry about that. Okay, for exhibits S3 and S4, the defendant correctly agrees these disclosures meet ICR 16B and 7. So these are going to be two separate witnesses, expert witnesses. For exhibits S5 and S7, the state disclosed two likely fact witnesses as experts out of an abundance of caution and was clear about this intent. Okay? So, what this tells me is the state said in their disclosure, look at, we have S5 and F7. We have Mary Jo and John. They're going to, be fact witnesses as experts out of an abundance of caution and was clear about their intent. Okay, so they're going to call these people as fact witnesses, but the defense may feel like they should have been sworn as expert witnesses and they should have had their curriculum vitae and opinions and everything else beforehand. But they're not going to, the prosecution has said these two, S5 and S7, are not going to be sworn in as expert witnesses. They're just going to be fact witnesses. But he listed them and put them on the list with their experts out of abundance of caution. And they let the defense know that. This is only out of abundance of caution, just so you guys know what witnesses we got. These two aren't going to be experts, but we're giving them to you now with our expert list, point blank. The defendant's argument that the state erred in this good faith disclosure is without merit. In the event either of these witnesses are in fact experts within the meaning of ICR 16B7, it is clear from each disclosure exactly what these witnesses will testify to based on the provided disclosures. So they have told them this is exactly what these two witnesses are going to say. We're not calling them as experts. We're calling them as fact finders and like a lay person. But this is what they are going to say. They didn't have to give that. Unless it was an expert, they didn't have to give them this at this point. But they did out of abundance of caution. And guess what? The defense is still not happy. Okay. For Exhibit S8, the state disclosed the vehicle identification expert, S.A. Emel. The disclosure specifies he will testify to his use of the forensic audio, video, and image analyst program. The forensic audio, video, and image analyst program was used to determine the make, model, and year of a suspected vehicle involved in the 1122 King Road burglary and homicides in Idaho on or about November 13, 2022. It is clear from the disclosure that this witness is an expert in vehicle identification. The defendant has repeatedly been provided the images relied upon, which are detailed in his report of examination, which was attached to the state's disclosure. So his report is attached. They're still not happy. The state's disclosure provides the defendant adequate notice of S.A. Emel's anticipated testimony to satisfy the requirements. For Exhibit S9, the state disclosed Kathy Mabut. What a last name, Mabut. My butt hurts. My butt. Okay, sorry. Sorry, Kathy. Don't come at me. The Latah County coroner. The state specifically detailed each opinion to be proffered. The opinions were supported by the attached death certificates authored by the coroner's CV, and the coroner's CV. The defendant fails to mention that in addition to being an attorney and an elected coroner, Ms. Mabut was a registered nurse for 44 years, which is detailed in her CV. The state's expert disclosure satisfies the requirements of ICR 16B7. So they gave, I don't know what the defense said about this, because the state is saying, Yeah, and they detailed each opinion to be proffered. They have her CV, and the defendant fails to mention that in addition to being an attorney and an elected coroner, Ms. Mabut was a registered nurse, which is detailed in her CV. Wow. Okay. So she's going to be testifying. Exhibit S10, S13, and S14. The state disclosed forensic detectives. Okay, so these exhibits are from forensic detectives. These disclosures specifically listed each forensic item to which the witnesses would testify regarding. The witnesses' expertise in the process of extracting and identifying the data that is on each of the listed devices. Okay, so this is going to be like all the like Apple devices and like all that stuff that they got warrants for, like Amazon and Apple and all that stuff. The contents of each of these devices has been disclosed to the defendant. Any opinion related to that extraction, whether a connection was found or not. He. See that, you guys? So they're not saying whether they found something or not. But what the prosecution is saying is any opinion related to that extraction, whether a connection was found or not, is not an expert opinion. As a result, the disclosures meet the requirements. So obviously, the defense doesn't know if they found a connection between Bryan Kohberger and these victims, and they're worried about it. They want to know. But the prosecution is saying, we don't got to give that to you right now. It's not an expert opinion, right? That's going to come out in court. You're going to have a chance to cross-examine. Remember what we read just earlier? But it seems to me, because it's the defense that's fighting about all this and saying that the prosecution didn't give them anything, and they want sanctions. They want all this stuff thrown out, including warrants and everything. But these specific ones, they want thrown out for a reason. Are they worried that there was a connection found between Bryan Kohberger and any of these victims? We did hear that they found messages that Bryan Kohberger had sent to one of the victims. I'm sure they don't want that in. The defense is not going to want that coming into court. For exhibits S11, defendant correctly agrees this disclosure meets the requirements. For exhibits S12, the state, what page are we on here? 8. The state disclosed an expert on crime scene reconstruction and blood stain pattern analysis. The state's specially detailed each opinion to be proffered. Okay? The opinions were supported by attached reference report and CV. Okay? The state's disclosure provides defendant with adequate notice of this expert's anticipated testimony to satisfy the requirements. As noted in court, the defendant has identified areas through the disclosure for cross-examination which only evidences the adequacy of the disclosure. See, they're throwing it at them again. Okay, this part here. Okay, because the defense has been complaining that they don't have all this information that they need, and they can't find their own experts to refute this because they don't have all the information, blah, 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 blah. So he's nailing at it again. The defendant has identified areas through the disclosure for cross-examination, which only evidences the adequacy of the disclosure. Defense should be able to cross-examine with no particular difficulty, satisfying the goal of Rule 16. Exhibits S15 through S25 all relate to Idaho State Police forensic experts. First, the defendant claims not a single DNA expert opinion or report was produced. This is simply not true. In each of these responses, the state refers the defendant to specific lab reports and the corresponding Bates numbers. The defendant's apparent argument that the state is required to make duplicative disclosures is unsupported. Like, okay, I don't care if you gave that to us way back when. We don't want to have to go search for it, so we want you to give it to us again. No, that's not how this works. You have that information. We gave it to you a year ago, right? It's not up to the prosecution to go searching for that and give it to you again. A simple reference to where the defendant can find the report is adequate. So they even said, this is where you can find that report. They don't have to give it to you. This is where you can find it. Go get it yourself. Like, it's almost like the defendant wants the prosecution to do part of their job too. Like, if you can't do this, Ann, then hire people to do it. We know you've got more than enough money because Bryan Kohberger has gotten tons more than anybody else. Each report provides a basis to determine what the expert's opinion is through the reference lab report. As an example, we get an example. The state is attaching Bates 93239354 for the court's review on how these disclosures comply with the requirements of ICR 16B7. See Exhibit S1 attached. The state follows suit in disclosures S16 through S20 and S22 through S25. The state's experts' disclosure regarding lab experts satisfied the requirements. S21, the state disclosed Rylene Nolan is as an expert. It is anticipated that this witness is actually a rebuttal witness. Now, if this is a rebuttal witness, they don't have to have those witnesses' CV or opinions or anything in until I think it was sometime in February, but they've given it to them anyway, right? Okay, so it is anticipated that this witness is actually a rebuttal witness. So they're going to rebut anything that the defense brings in, who is prepared to testify regarding secondary transfer if necessary. The state contends the notice provided is sufficient pursuant to Rule 16B, but reserves the right to amend this disclosure upon review of the defendant's guilt phase experts. So what that means is if the defendant is going to bring in experts regarding secondary transfer evidence or arguments, then they will bring this one in as an expert. But they're going to wait to see what the defense does. And they can do that because it's a rebuttal witness. They have longer times to give the defense the rebuttal witnesses, but they've already given them. So they've gone above and beyond what they had to do. As required by Rule 16J, the state will continue to supplement the response if the state later discovers or decides to use additional evidence. Lastly, the court determines that any of the disclosed expert disclosures, if the court determines that any of the disclosed expert disclosures do not meet the requirements, the state will promptly amend them. Any contention that the defendant has been prejudiced or does not have adequate time to respond is wholly unsupported. I think that they just want more time. I think they're trying to dig up more stuff that they can possibly use. And instead of writing 400-page motions, this is what they should have been doing over the last 8, 9, 10 months. And now time is coming to give their experts, you know what I mean? And I don't think they got them all together yet. So they want more time. So that's why they're pulling this. The defendant request for sanction is premature and without merit. Conclusion. The state respectfully requests that the court deny the defendant's motion to compel material and for sanction based upon the filings in this case pursuant to the 4th Judicial District Rule 5.3. The state is not requesting a hearing on this matter. So that is what the prosecution is now saying. Like, we've given you everything. What more could you possibly want? Right? We've actually given you more than what we've needed to give you. Because right now, the only thing they have to disclose to the defense is a list of their expert witnesses. They gave them a list of all the witnesses so far that they intend to call, even if they're not on the expert list. They've even told them about rebuttal witnesses that they may call. Right? They didn't have to do that yet. What do you guys think? What do you guys think about all this? I want to hear some of your opinions. Put them in chat. I'm waiting. What do you guys think? Let me see some of this chat here. Nana says, this woman is throwing tons of BS to see what will stick. Throwing it up against the wall. Yes. Like I said, I get it that they're going to try everything possible to try and get the best outcome for him. But there's a line there. There's a fine line. Carol says, well, I want to win the lottery, but it ain't happening either, right? And I mean, you've got to kind of look behind what's being said in some of these. A lot of people that don't know legal jargon or how the legal system works or isn't familiar with legal proceedings and stuff like that wouldn't catch some of this stuff. So that's why I wanted to go over this with you. Like I said, I worked in this field for over 30 years. So I can see what she's trying to do, arguments that she is trying to make, but it's not working. And I don't think any of this is going, the judge is going to deny it right across the board. She wants, let me bring this up. Let me just go and get this. Hang on a sec. Okay, I'm going to have to put that over here. Okay, let me share this with you. Okay, so here it is. This is where it starts. Okay, 12/29/2022. You want to see how bad this record is? I'm not going to just use my little scrolly thing on my mouse to scroll through this, you guys, because we'd be here for the next week. You want to see the filings in this, and I would say 85 to 90% of this is Ann Taylor's frivolous motions. Watch. Watch how much is in here. Watch. I'm scrolling fast. Look at. Look at. We're not into 2024 yet. We're still in 2023 here. Look at. This is all filings in the Bryan Kohberger case. Here we're at the beginning of 2024 now. Look at this. Look at this. Okay? And then here's Lori's. Do you see how much is there? And I would say 90%, 85 to 90% of this is all Ann Taylor and her team with these emotions. And it's like, no wonder, you can't find anything. I mean, if the prosecution sneezed the wrong way, they're going to file a motion on it. Carol says, good God, where's Perry Mason? Right? They've got whatever do you think in a case like this, and I want your honest opinion, you guys, do you really think in a case like this that the prosecution is going to try and hide stuff? Obviously, the defense has it because they're making motions regarding that evidence that they said they don't have. And I don't think this judge, he ain't be playing. He ain't the one to play with, Ann. So, and these here, they want all of this thrown out. The genetic information, anything, the warrants and anything they got from Bryan Kohberger's parents' home at 119 Lambsden, anything they got from Amazon, the Google searches, Apple, AT&T, Pen Trap and Trace, anything from Mr. Kohberger himself and Mr. Kohberger's apartment. They want it all thrown out. So this is what they are going to do to try and do it. We just went through that motion and the state's reply that just blew Ann Taylor and her bull crap out the window. How can you file motions arguing stuff that's in evidence if you don't have that evidence? You claim you don't have that evidence. So how do you know that this stuff is in that you're claiming you don't have? Right? It's like me saying, look I gave you the rules of the pool. You can't jump in the shallow end. You can't dive in the shallow end, blah, 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 blah. And you say, Willow, you didn't send me those rules. And then a week later, you file a motion saying that the rules were unclear. The rules said no diving in the shallow end. It didn't say nothing about jumping in the shallow end. Wait, I thought you said you didn't get that disclosure. I thought you said you didn't get that list of rules. How are you making a motion on something you said you didn't have? Right? So that's the only way, that's the easiest way I can explain it. Here's Cat. Are you guys following? Are you following what I'm trying to say here? You guys aren't either you're not very talkative or my chat is frozen. One of the two. Let's see what else is in here. What's this? Order sealing defendant's amended memorandum and exhibit in support of Frank's hearing. Oh, yes. This was filed January 8th. That's when she tried to file like hundreds of pages, and the judge says, no. You're limited to a certain amount of pages, and unless you refile this within those set amount of pages, then this is going to be tossed. So they did file it. It is. It's crazy. Like, how can you argue saying something in that report isn't right if you don't have that report, like you say? You're telling us you don't have that report. So how do you know what's in it? Oh, we paying attention. It's been hard, you guys. I don't know what is going on with my neck. I got to go back and see the doctor, but I've been getting really severe headaches, and I've been doing all this physiotherapy crap and everything for my neck because I got severe arthritis in it, apparently. So the doctor sent me to a physiotherapist. I've been doing everything, and it's not helping at all. It's making it worse, I think, because I wasn't getting headaches like this. But see, like everything, I was hoping that once this went to Ada County and in front of Judge Hippler, that we would start at least getting some things that weren't sealed. And we're getting very little. Very little. So on the 23rd, I'm going to be covering it. It's going to be live. His next court hearing, I'm going to be covering it. What are we going to get to hear? Right? Are they going to just, show us the courtroom and just mute out pieces that are under seal? I don't know. I don't know how they're going to do it. But I'm going to be anxious to hear what the judge says about right here. The motions to suppress the Lambston, the Amazon, the Apple, the AT&T first warrant, cell phone, Google, Pentrap. They wanted more than that. Here it is here. These are all the things here that, oh, you guys can't see. Hang on. Hang on a second. I'm going to share this differently. Oh, let's just share the window. Okay, can you see? Yes, now you can see my pointer. Let me get this off screen. All of this stuff is what the defense wants to suppress. All of this. The warrant for his apartment, the warrant for Apple, the arrest warrant, the cell phone, the Elantra information, the first warrant, search for Mr. Kohberger, the trace, the warrant for Mr. Kohberger, Apple, AT&T, the search of Mr. Kohberger's person, the Pentrap trace, the Amazon things that they got in a search warrant for Amazon, the defendant's amended motion. So, I mean, like, this is, they want everything thrown out against him. That even the warrant for his arrest, even the information that they got searching for him, they want it all thrown out. Right? I would not be surprised if Bryan Kohberger was saying, look it, I know the law. I'm a PhD student in criminal law and whatever. Do this, do that, do this, do that, do this, do that. Like, I've never seen a lawyer say, well, I know for the last, 100 years, the grand jury is, by the preponderance of the evidence or however they do it, it's not beyond all reasonable doubt. That's for a jury. But we want that changed for the grand jury. This is the way it should be. But that's not the way it is. Well, that's the way it was back in the 1800s. Remember that? Well, things have evolved, a new precedent set, new rules set since then. Stop it. And I'm sure Bryan Kohberger was behind some of that. So I agree, Carol. I totally agree that he is behind some of these things. But Ann Taylor, like I said, you guys, we scrolled through this. Look at this. Look at this information. This is just for 2024. Then now we're into 2023. Like, look at this. All of this is just his case. You'll see it coming up. See? For Bryan C. Kohberger. All of this. All of this. My computer is getting overloaded by it. Look at this. We're still going. Down to here. And here, this was just put in. It says it was filed January 8th, but it was just put into the record. Well, they're saying the 8th, but that wasn't there. This stuff was all afterwards too. So they're changing the dates on these to when it actually went up online. But anyway, order sealing Exhibit A to defendant's motion to compel. You know what I mean? Like, everything is being done under seal. So all we can do is, if you understand the legal system and what to look for clues as to what this is that's under seal, then this is just, no good to anybody. But they're still fighting this generic IGG. This has already been decided upon, yet they're fighting it again. It's already been decided on. So, I don't know, you guys. It's just a circus. So I wanted to bring that to you guys. I am planning, as long as I can get rid of this headache. I want to do a read. I was asked to do a read on, let me just see if you guys know about this case. Ronnie Russell. Don't give me any information about it, please. I did do the one on Brent McGee, but I was also asked to do one on Ronnie Russell. So hopefully I can get that done tomorrow, and it will be up Thursday. If I can get it done tomorrow for members, you'll be able to see it tomorrow. For everybody else, you'll see it on Thursday. That's one of the benefits of being a member of the channel. You get to see everything ahead of time. So there's that. I'm hoping to get that done tomorrow, you guys. So pray for this headache to go away for me, please. So I'm going to leave it at that. I'm not going to take up much more of your time. If there's anything else that does come out that I feel is important, I don't want to waste your time. I don't want to waste my time. It takes a lot to get these things together. And you know me, I'm still learning this Restream because I'm so used to StreamYard. But I think I'm getting it down pat. So bear with me as I learn a whole new system here. But it takes a lot to get it together. So I appreciate you guys being here and watching and, clicking on it and commenting and liking the video. Please don't forget to like the video. It's free to do. We had 22 people in here and only 16 likes. So maybe you guys, that tells me that there's a lot of people that are coming in that don't like these things, don't want to see this stuff. Thank you, Kat. You're a sweetheart. Thank you, Kat. Thank you. You're a sweetheart. It's just this headache, and it's not like I can't deal with it. It's annoying. So, okay, so I'm going to let you guys go. Get back to what you were doing. If anything else does come out, I will be sure to pop on and let you guys know. And until the next time, please take care of yourselves. Please stay safe. Always be aware of your surroundings. Please keep California in your prayers also. Okay, the fires are raging again. So, and we have one of our mods that live right, it's starting to lick at her door in California, and that's Marie Burks. So please keep everybody in California and our mod Marie Burks in your prayers, that they are all safe. I love you guys.